Welcome back, future lawyers. This video is 2021-2022 UP Law Center suggested answers to bar exam questions in legal ethics. Now let's get started. Question. While attending a wedding, a lawyer got to dance with and talk to another guest who ended up sharing details of their marital problems. When asked by the guest, the lawyer explained the distinctions among legal separation, annulment, declaration of nullity, and divorce. The lawyer went on to not only extend advice, but even to map out a strategy on how the guest's marital woes could be addressed. At the end of the conversation, the lawyer and the guest agreed to meet at a later time to continue their discussion. After the dance, the lawyer returned to their seat and shared with their best friend the guest's marital problems. Question. Did the lawyer breach attorney client privilege? Explain briefly. Suggested answer. Yes, the lawyer breached attorney client privilege. The breadth and the depth of their discussion, which included legal distinctions and strategies, and the agreement to meet again at a later time, signify that both parties intended to form an attorney client relationship, even in the absence of a formal engagement agreement. The lawyer already owed the guest the duty to preserve a client's confidence under Article 21.01 of the Code of Professional Responsibility. Such confidential information includes communication with an attorney with a view to obtaining professional advice or assistance. In versus Magulta, the Philippine Supreme Court summarized the governing principles for the privilege. 1. An attorney client relationship is established from the very first moment the client asks the attorney for legal advice regarding the former's business. To constitute professional employment, it is not essential that the client employed the attorney professionally on any previous occasion. 2. It is not necessary that any retainer be paid, promised, or charged, nor is it material that the attorney consulted did not afterward handle the case for which his service had been sought. 3. If a person in respect to business affairs or troubles of any kind consults an attorney with a view to obtaining professional advice or assistance, and the attorney voluntarily permits or acquiesces with the consultation, then the professional employment is established. Likewise, an attorney client relationship exists, notwithstanding the close personal relationship between the attorney and the client or the non payment of the former's fees. Alternative answer. The lawyer did not breach lawyer client privilege because there was no lawyer client relationship or prospective relationship when the guest made disclosures to the lawyer in this case. In the case of Hajula versus Mandiada, the Supreme Court held that the essential factors to establish the existence of the attorney-client privilege are: number one, where legal advice of any kind is sought; two, from a professional legal advisor in his capacity as such; three, the communications relating to that purpose; four, made in confidence; five, by the client; six, are at his instance permanently protected; seven, from disclosure by himself or by the legal advisor; eight, except the protection can be waived. In this case, there is no indication that the lawyer provided legal advice in a professional capacity. The guest had no intention to consult the lawyer. The guest just happened to talk about marital woes to another guest who happened to be a lawyer. There was no lawyer-client relationship when they discussed the issue. The discussion was open, which did not establish a lawyer-client relationship. Hence, there can be no breach of lawyer-client relationship. Question. During work, an overseas Filipino seafarer was seriously injured after falling into the elevator shaft of a foreign vessel. After initial treatment in Singapore, the seafarer was flown to the Philippines to continue medical treatment. While the seafarer was confined in a hospital, two paralegals representing a lawyer approached the seafarer offering that lawyer's services at a significantly discounted rate. They explained that they could sue the employer for indemnity and added that the lawyer had a good track record at the National Labor Relations Commission. The paralegals even bragged about the lawyer's connections at the Supreme Court. The seafarer agreed to engage the lawyer's services. The employer proposed to settle the case out of court and eventually paid 5 million pesos. The employer deposited this amount in the lawyer's bank account. The lawyer tried to remit 1 million pesos to the seafarer, making it appear that the settlement was only for that amount. The seafarer refused to accept the amount of 1 million pesos as no prior approval had been given to the lawyer to settle the case. The seafarer filed a complaint before the Supreme Court for the lawyer's disbarment. Does the seafarer have legal grounds to file the complaint? Explain briefly. Suggested answer. Yes, the seafarer may institute a disbarment case against the lawyer on the basis of violations of the Code of Professional Responsibility. The lawyer violated Canon 16 of the Code of Professional Responsibility, as it is the fiduciary duty of the lawyer to account for all money collected and received for his client. Since the agreed settlement is for 5 million pesos, the lawyer should not have deceived his client by making it appear that the 1 million pesos he remitted was the full settlement. The lawyer also violated Canon 15 in not obtaining the client's approval before settling the case. As held in Sison versus Camacho, the Supreme Court disbarred Camacho for not seeking the approval of his client when he entered the compromise agreement with the opposing party. The lawyer should first seek the written consent of his clients before entering into a compromise agreement. 3. The lawyer violated Canon 1 for his deceitful conduct. 4. The lawyer also violated Canon 7 for failure to uphold the integrity and the dignity of the legal profession through his misconduct. Question. The lawyer of an accused filed a motion to inhibit, alleging as ground that the judge was the cousin of the private complainant, which is within the fourth degree of consanguinity. Should the judge inhibit? Explain briefly. Suggested answer. Yes, the judge should inhibit, as the relationship between the judge and a private complainant is covered by the compulsory disqualification provisions of the new Civil Code of Judicial Conduct, which specifically provides that a judge shall take no part in a proceeding where the judge is related by consanguinity or affinity to a party litigant within the sixth civil degree or to counsel within the fourth civil degree. Next question. A known tax lawyer in Iloilo became a member of the Integrated Bar of the Philippines in 1974. This lawyer later migrated to the United States and became an American citizen in 1989. In 2006, the lawyer reacquired their Philippine citizenship by taking the oath of allegiance as a Filipino citizen before the Philippine consulate in Washington, D.C. in the United States. The lawyer now intends to return to Iloilo and resume legal practice. Can this lawyer continue to practice law in the Philippines? Explain briefly. Suggested answer. Yes, the lawyer can continue his practice of law in the Philippines. The practice of law is limited to Filipino citizens, and since the known tax lawyer already reacquired his Filipino citizenship under the Citizenship Retention and Reacquisition Act of 2003, he will need to file before the Supreme Court his petition to resume his practice of law. As held in Petition for Leave to Resume Legal Practice of Law, Benjamin Nacanay, petitioner, the approval of his petition is subject to the following conditions. 1. He must pay all his IBP dues from 1989 to 2006. 2. He must pay and obtain his professional tax receipt. 3. He must comply with his mandatory continuing legal education requirements. And 4. He must retake his lawyer's oath. You are the counsel for Bonnie and Clyde, who are accused as co-conspirators in a murder case. During arraignment, they both pleaded not guilty. In the course of the trial, Clyde admitted or confessed to you that it was actually Bonnie who committed the murder and that he merely helped Bonnie dispose of the body. Clyde tells you that he wants to plead guilty and directs you to inform the prosecution and the judge that he wants to testify against Bonnie as a state witness. Can you continue to represent Bonnie or Clyde or both? Explain briefly. Suggested answer. I will recuse myself from representing either Bonnie and Clyde. Rule 15.03 of Canon 15 of the Code of Professional Responsibility provides that a lawyer shall not represent conflicting interests except by written consent of all the concerned given after a full disclosure of the facts. There is conflict of interest when a lawyer represents inconsistent interests of two or more opposing parties. The test is whether or not, on behalf of one client, it is the lawyer's duty to fight for an issue or claim, but it is also his duty to oppose it for the other client. In brief, if he argues for one client, this argument will be opposed by him when he argues for the other client. As applied to the instant case, representing Bonnie may invite suspicion of unfaithfulness or double dealing with the information given by Clyde, who is a co-conspirator in a murder case. On the other hand, representing Clyde with the information he has given may create an impression of impartiality in the course of the proceedings towards the co-conspirator, Bonnie. Hence, under the above cited rule, I will not represent Bonnie or Clyde. Question. Identify 5 duties of a lawyer as stated in the lawyer's oath. Suggested answer. Any 5 of the following are duties of a lawyer stated in the lawyer's oath. 1. Maintain allegiance to the Republic of the Philippines. 2. Support the Constitution and obey the laws as well as the legal orders of the duly constituted authorities therein. 3. Do no falsehood nor consent to the doing of any in court. 4. Not wittingly or willingly promote or sue any groundless, false, or unlawful suit, nor give aid nor consent to the same. 5. Delay no man for money or malice. Conduct oneself as a lawyer according to the best of my knowledge and discretion. Conduct oneself with all good fidelity as well to the courts as to my clients. Impose upon oneself these voluntary obligations without any mental reservation or purpose of evasion. And we're done. Thank you so much for watching. Remember, every day is another chance to get one step closer to passing the bar. You're doing great, future lawyer. See you next time. Bye.